welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Peter Roscher, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Hello, everyone, and welcome back to our latest edition of the Arbitral Insights podcast series. And I'm delighted today to have as our guest Chirag Karia QC. Hello, Chirag.
Hello, Gautam. How are you?
I'm very good. Great to have you here. I'm delighted. It's a real honor to be speaking to you today. For those of you who haven't yet met or know Chirag, I'm going to give you a little background on him. He's truly exceptional. He is a very highly regarded QC here in London. He is a member of Quadrant Chambers in London. His core practice areas encompass commercial law, shipping, commodities, energy, and arbitration. He is well known and extremely well recognized for his incisive cross-examination skills. So I'm delighted that I'm actually going to be on the other side of the fence today, and I'm going to be cross-examining you, Chirag. But Chirag also has a very interesting background. Before he became a barrister, he spent 10 years practicing in California, where he still is licensed. And I'm sure we'll talk about that, Chirag, in the course of this discussion. One of the other reasons why I'm delighted to be speaking to Chirag today is that he is one of only a few ethnically diverse senior Queen's Counsel at the English Bar. And it's wonderful to see you doing so well, Chirag. So again, a very warm welcome, Chirag, and I look forward to our discussion today.
No, thank you so much, Gautam, and it was a very kind introduction.
Well, it's all appropriate and all correct, which is, one of the things I learned as a very young lawyer, Chirag, which I can't resist telling you, is someone told me, saying things is easy when you speak the truth. And
yes.
So saying what I said was very simple.
Thank you.
So let's wind it back, Chirag. You've had a very interesting career, and we'll talk about that. And there's obviously a lot more to come from you. But tell us about how it all started. How did you first get interested in a career in the law? So if you could just tell us a little bit about that.
I came to law in a very indirect way. During my youth, I was fascinated by science. So I was always going to be a physicist. And I recall my father, when I must have been about 11, 12, saying, Chirag, you should be an advocate. And I said, no, never. I'm going to be a scientist. I'm going to discover something. And in fact, I went to Cambridge to do natural sciences. My career was planned out and I wanted to be a physicist. And during my year off, I actually worked for a company called the National Nuclear Corporation, who were doing the safety case for the Sizewell B nuclear reactor. And I think that year off, away from the treadmill of school, what is now GCSEs, O-levels, A-levels, etc., just sort of gave me a bit of perspective. And I started to look at, what it is I really wanted to do and could see myself doing for the rest of my life. And I actually, went and talked to some consultant doctors because, as you know, or maybe you don't, but certainly in my day and age, if you were a scientist and you were Indian, you became a doctor, right?
I know all too well, Chirag. I know all too well.
And I realized that this is not what I wanted to do. It's not what I was cut out to do. But I actually spent some time with a local set of criminal barristers in Leicester, where I lived. And I spent some time with them, and it just absolutely blew me away. So I decided to change to law. I did law, qualified at the bar, briefly became a tenant, and then I got a scholarship to study at Berkeley in the United States. I went to the law school there and did an LLM. And if you've ever been to the San Francisco Bay Area, you will know that it is extremely seductive. And
it is.
Having gone there for 1 year, I ended up staying there for 10. As I worked as a litigator, primarily federal court, but also state court litigation. And also I did, in the last couple of years, some corporate law in Silicon Valley, all at the height of the dot-com boom. So I've sort of been around, and obviously I've been back since 2000 in London. acting as a commercial barrister. So that's a potted history.
No, fascinating, absolutely fascinating. And I mean, one thing also, since you mentioned sort of the stereotype that people from the same heritage that you and I share often have, is that you're often sort of seen as either a scientist of some kind, or you go into accountancy. And I
Yes,
think law is one of those things that's often overlooked. So I
yes,
think I mean, you and I have fallen into that middle ground where no one, when no one was looking,
that's
and they
right.
were expecting us to pick it to be going on the other flanks.
Yeah.
But no, but that's really interesting. I mean, in terms of your background and when you were studying and then working in California, and you look at how legal practice is here, where you've spent the majority of your legal career. How would you, I mean, what would be the main differentiators between your practice in California and practice here?
The main the main reason we came back to England from California wasn't the weather, as you would imagine. It was because I wanted to come back to the bar. I am a firm believer in the divided profession. I think it is by far the most efficient. And I know that that is an extremely difficult thing to explain to foreign lawyers. But having practiced in both systems, it is much more efficient. I get to do what I am best at and also what I enjoy the most. So I'm either doing advocacy, and as you know, in our type of work, that's, not a very large percentage, can be, 15, 20, 30% of the time if you're lucky. But the other time is advising, or giving considerable thought to some knotty legal issues or some strategic issues, whilst I'm unburdened by dealing with disclosure and dealing with the client and all of that stuff, which I used to do as a litigator in a firm in the US, which meant that there was only me who was handling both the client and the disclosure and preparing for the trial. And I think that's inherently very difficult to do. The other thing is, the big advantage is you end up specializing, not by subject matter, but by skill. So I do a lot more advocacy as a barrister than I would have done, that I did as a litigator, because most cases settle. You have what they call in the US motion practice, and you have, but most of that's done on paper in any event. So the specialization really assists the system, because it means that it's something that I do day in, day out. And therefore, hopefully, I'm a lot more adept at it than if you're just doing it, once a year or twice a year. So that's where I think our system has great benefits. It also has, of course, the fact that certainly in the courts, and this happens in arbitration as well, if there are the same or similar, a group of advocates and a group of arbitrators or judges who trust each other, it allows things to move much smoother. And they trust each other because they know each other, that, for no other reason than that. And I think that helps considerably. And ultimately, I think, one has to look at what the market is saying. And I think London, despite, competition from places like Singapore and elsewhere, is still doing very well. And there's a reason why people come here. And I hope, and I sincerely believe, it's because of the quality of the service providers, law firms like Reed Smith, the bar, and all the other experts and all the other support that London provides.
Yeah, no, I agree. I often, tell young lawyers who I talk to that English law is probably one of our country's greatest exports,
Yes.
because frankly, I mean, as you said, parties can have no affiliation or link to this country, but they will litigate or arbitrate here. So, then just tell us, because one of the things I always find very interesting when I speak to distinguished people like yourself, Chirag, is, when you were junior and when you were coming up the ranks, both in the US and here, who mentored you and who inspired you to do well and to achieve your potential. I wonder if you could just share with us some of your experiences of those who mentored and inspired you, and indeed who continue to mentor and inspire you.
Well, it sort of the first one actually goes back to my university days, and there was a wonderful man called Mickey Dias, and people might remember he was a
He wrote a textbook.
yes,
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 yes.
he did a textbook on tort. He also at the time was the editor of Clark and Lindsell. I studied both tort and Roman law, which is one of the things you had to do at Cambridge with him, and he once you've met him, he was an amazing, amazing individual, a man of great learning who approached the law with passion and precision. So we used to go into his room, and it was almost like a holy, it's a temple, and we'd sit there, and he'd have his gown on, and he will,
Yeah.
and he had this wonderful accent. He was Sri Lankan, and he would, talk about the difference between liability and suability, and sort of we learned the precision and also the love that you can have of the law, and the logic, and then also trying to think outside the logic as to why judges were doing or deciding what they were deciding. So he was my first mentor. When I went to Berkeley, there was a professor there called Willie Fletcher, who actually, I think he's retired now, but he became a judge of the Federal Ninth Circuit, and I studied federal courts with him. He was, again, a great teacher to learn from. When I was at Baker McKenzie, there were a couple of partners that I worked with and who nurtured me, and to whom I'm always very grateful. My pupil master actually was Sir Julian Flo, now the Chancellor of the High Court.
Yes.
And I was his pupil when he was a very busy junior. Just to see him juggling everything. And what I saw my job as, and one of the reasons I suppose I got taken on, is to sort of try to help him whenever I could. Say, okay, let me deal with that point. Can I, let me write you a note. But it certainly showed me, how you can juggle workload and also be honest to yourself and honest to your clients, right? Saying, look, I'm good, and this is something I don't know if you find, but one has to explain to clients, especially people from abroad, that just because I'm giving you negative advice in conference doesn't mean I'm not going to be arguing your case. I'll be arguing your case to the very best of my ability. But I wear two hats. I'm an advocate, I'm an advisor. And when I'm an advisor, I'll tell you what I think is going to happen, because I wouldn't be serving you well if I suddenly looked at the world with rose-tinted spectacles and said everything's going to be fine, when, in my heart and my intellect tells me that we have these difficulties. But don't be afraid, I'm not, none of that's going to come out when I am, making my submissions. So those are the people I would point out.
So it's a very impressive list, and
Yeah.
and look, and I'm the same. There are many people who've inspired me, but one thing you just said there, which is very interesting, is how to convey things, candidly to clients, but also fight hard for them. And I think
Yes.
that's one of the great things that I know senior counsel like yourself do so well, because we do have an adversarial system. It's there to argue the points out, and certainly a point that, or a case that may not always have a great prospect, can come good because of the legal points, and that may be something that clients don't always see. So
Yes.
just in terms of your practice, which is very diverse, because as I mentioned in opening, shipping, commodities, energy, commercial law, international arbitration. Are there any cases that stand out to you that you've done on the law? So, on points of law that have been particularly interesting and that you look back on and think, wow, those were really, really significant legal points that I argued.
Yes, I suppose there are two cases that I would say fall within that. The first one is the case we call the Yusuf Sepenoglu, is all about anti-suit injunctions. And this was a case where I was acting for a P&I club who had insured a vessel that had grounded and the cargo was lost. And the charterer sued the owner in London arbitration because there was a London arbitration. But then because the charterer was based in Turkey and the vessel was undertaking a liner operation from Turkey, it also sued the P&I club under Turkey's right of direct action statute within the Turkish courts. And we applied urgently for an anti-suit injunction against the charterers, on the basis that, first of all, they were in breach of contract, because although there was no direct contract between us and them, they were seeking to take the benefit of the insurance contract and therefore had to do so in accordance with the terms of that contract, which required arbitration in London. And on the second basis, vexatious and oppressive. Now, the difficult thing on the first ground was that there were conflicting Court of Appeal decisions, the first one not having been cited in the second case. So in the first instance, that proved to be a hurdle, but we succeeded. I managed to persuade the judge on the vexatious and oppressive basis. And then the matter went to the Court of Appeal, and the Court of Appeal agreed with me that the second decision was wrong and ought not to be followed, because just logically it didn't make sense. So that the principle has been established that if you seek to take the benefit of a contract as a third party, then you are bound to do so by reference to the dispute resolution clauses in that contract. The other one was the DC Western, which was a marine insurance case. And that raised a lot of very interesting issues about what a peril is in insurance, and whether, what it means to have a fortuity, because there was a lot of argument that the vessel was defective in a certain way upon sailing, and therefore it was certain that the vessel would experience ingress of water as she sailed. We argued that was nevertheless a fortuity. There is some very interesting discussion in the judgment of Mr. Justice Popwell in that case as to what is the meaning of a fortuity. So I'd say, those two. As far as sort of personally affecting, there is an arbitration I did. It was technically it was a management agreement, a ship management agreement, but really it was almost a quasi-family dispute within a very prominent Greek shipping family, where somebody who had been running their operations from London was effectively cut out and left out to dry because he had had some heart problems and wanted to work from home. This is several years ago, and he was just summarily just cut out. It wasn't an employment issue, it was actually a contractual issue. And that was a case where my solicitors were doing it on a no-win, no-fee basis, and it really affected the individual, which we get very rarely in our cases. It isn't an individual who's affected; it's a big company or generally big insurers, and that was quite heartening. So I got to sense what people who practice in other areas get to feel. So I think those are the cases I would highlight.
Fantastic. No, great. I don't know. I mean, I couldn't resist asking you that because I know you've got a great love of the law, and also the areas of your practice are very law intensive. I mean, one of the things that I remember even as a law student is most of the law of contract and a lot of the law of tort is based on shipping law.
Yes.
And there are lots of legal points that come out of it. I mean, I still have nightmares about the Swiss Atlantique, for example. But anyway, we won't get into all of that now. But tell us a little bit about. We've been talking about arbitration, and that's a big part of your practice as well. I've got a couple of things to ask you, really. On that, arbitration is clearly a very popular mechanism for a dispute resolution these days, but it's not perfect. There are a number of things that can definitely be improved as part of the process, including the old chestnut about how long it takes to get the award once you've actually finished the case. But from your perspective as someone who is both counsel and an arbitrator, Are there things that we can do as an arbitration community to improve arbitration?
I would say two things come immediately to mind. The first one is page limits. International arbitration, I find, is drowning in paper, and that may well also be affecting the period it takes for the award to come out. I mean, it's not the only thing because people are taking on too many appointments or whatever, but trying to encourage brevity would be extremely helpful, it seems to me, because after a while, people get lost in paper and you're just answering paper. But at the end of the day, the arbitrators or arbitrators have to sit back and absorb all of this. And saying the same thing 5 different ways is not really, I find, helpful. If you say it once, then I think that should be enough. And allied with that is, and again, you can see that I'm coming at this from an English advocate's point of view, is maybe a little bit more interactive advocacy, which I know particularly those from the civil law system find probably a bit too intrusive. But, just asking questions and indicating where the tribunal needs assistance. I mean, as an advocate, as you well know, both, certain arbitrators are quite helpful in that way, others aren't. And similarly with judges, some judges are interventionist, although these days you don't get that. But some will just listen. And actually, those are the ones I find the most difficult because, we really I'd rather have a judge or an arbitrator say, well, Mr. Karia, you say this, but, I'm having difficulty understanding how this works or what, is this correct? Now, it does put the advocate on the spot, and the arbitrator has to sometimes, and same with the judge. If the judge spots that the advocate has no answer to give, then just let it pass, because we've all been there where a particular question is asked and you try to answer it, but there is no answer. But otherwise, often there is. Well, yes, the answer to that is look at this piece of evidence. And it's better to have that clarified in the arbitrator's mind during oral advocacy as opposed to the arbitrators then delving through all the papers trying to find that answer and sometimes not finding it. So those are the two things I would suggest.
No, and I agree with you. I think those are two really important things. And I wholeheartedly agree with you, Chirag. And you and I didn't even go through these questions in advance. This is very much just, us having a chat. But I couldn't agree with you more about page limits. I think page limits are so important because otherwise we have what I call arbitigation.
Yeah.
Which is just a hybrid of arbitration and litigation. And, as you and I will remember, when Lord Wolfe brought in the Wolfe reforms, one of the things he wanted to get rid of was the war of attrition, which litigators were constantly getting into. And I do feel we need sort of page limits. And also, I couldn't agree with you more about the whole thing about arbitrators being more discursive. Because, as you say, some of them will chat, but some of them will just sit back and listen and take notes quietly and not ask questions. And I think, so I know I fully agree with you on those points. And, do you find, when you sit as an arbitrator, do you find the process of writing an award something, and this is going to sound strange, do you enjoy writing awards, or do you find them, because, you're used to arguing one side of the case and then your opponent argues the other side of the case. What's it like for you when you're writing an award and you're thinking about both sides' submissions? And, how do you ultimately whittle it down?
Yes. Well, I actually find it so relieving that I'm not, as an advocate, you're always, you're looking at the other side's arguments, and even before you read the other side's submissions, there's a bit of trepidation. Even though you've done the case, there's a bit of trepidation because you don't know what you're going to see. And you don't know whether you're going to find an answer to it. So, it's very challenging, and I love that adrenaline, but it's there. As an arbitrator, the adrenaline's slightly different. It's, I need to get the right answer. I need to be fair. But I'm not, on my mettle to make sure, I spot every point and I can answer it and I can think of an answer. I have the party submissions. And what I really need to do is to think through, is to say, well, what is the right answer? And so to that extent, it is to a certain extent a bit like writing opinions and advices, which is, you do and I do as well. Except it's, this is one where your decision is going to be determinative. And that, of course, places an additional responsibility. But certainly I find it less stressful than being an advocate. But that's not to say I love the stress that as an advocate. I mean, I think, you
No,
know,
I know
I'm
what
an
you mean.
adrenaline junkie like that. So, yeah.
I love it. I love it. Adrenaline junkie, Mr. Karia. I love it. I love
Yeah,
it. Let me ask you. We're coming towards the end of the discussion, but I've got two other areas to cover with you. One of them is an important area to you and me, and to so many others
yeah,
from our background, and that's achieving better diversity, equality, and inclusion in the law.
yes,
And I have no embarrassment in saying very proudly that I admire you hugely, Chirag, because you are doing really well. You've got a great name at the English bar, but you're one of only a few people like you who are in that role. And you and I would love to see more people like us doing as well as you and your head of chambers, Poonam Milwani, and other people who you and I know. But there's just
yeah,
too few of us around. I know things are changing because it's in many ways a generational thing. As people get a bit more senior, like you and me, we see more people coming through the ranks. But what can we do more to ensure that we make the legal profession a lot fairer and better and more in keeping with our society at large?
Well, first of all, I think I should say that almost everything that you've said about me applies equally to you. So, Gautam, you're a very senior partner at Reed Smith, and so doing international arbitration and highly regarded in that. So, I think I've been getting too much of the acclaim, and I think a lot of it needs to go to you as well. I think that we need to do two things. First of all, we need to do outreach to people who would not think of law as a career for them, because that's for other people. Certainly, when I went into the law, and it maybe the same was for you, culturally it was very different from where I was coming from, class wise and of course, but in racial terms as well. It is a lot more diverse now than it was when you and I started. But doing outreach, I participate in something called Prime Commitment with a particular law firm that puts on events to introduce 17 and 18-year-olds to the law, just to sort of, talk to them, bring them into chambers, bring them into the law firm, take them around the Royal Courts of Justice, because these are buildings and areas most people have never seen. I mean, unless you're a lawyer or know a lawyer, there's no reason why you would see the Temple or Lincoln's Inn or the Royal Courts. But they are actually quite inspirational places. And if you can just inspire one person to say, actually, and I think it's the job for people like you and me to say, look, I did it. You can do it. So I remember an extremely touching encounter on my Silks Day. So I was just coming out of Westminster Hall in Parliament after being granted silk, and I had all the long, my wig and everything, the bell-bottom wig, and there was a group of school children, and I think they were probably from Tower Hamlets or something, because I think a lot of them were of ethnic minorities, and they came up to me and they said, hey judge," and and I think more, I mean, it wasn't my outfit, which was outlandish as Silk's, formal outfit is, with breeches and long wigs, because there were lots of
Mm,
people with
yeah.
that outfit on that day in that area. But I think just seeing somebody who looked like them was something they'd not seen. So I think that's one thing, is we can be role models and show people that this is possible for them. Secondly, of course, within our own organizations, we can make sure that people have equality of opportunity. And I think we're slowly getting there. I mean, we are slowly getting there, but I think we can do more by encouraging people who otherwise would think that this is a different world, populated by public school boys and girls, and I certainly wasn't one of them. And so, I think just telling people that, look, you don't need to be that.
Well, I think that's so right, and you've put it very eloquently. And I dare say, Chirag, when you were growing up in Leicester and
Yeah.
when I was growing up in northwest London, we had very similar backgrounds, I think,
Yeah.
because I certainly had no idea what Lincoln's Inn was or the temple was or anything else. And, my perception of lawyers was purely from what I saw on TV, Ron Pole at the Bailey and
Yeah,
that sort
that's
of
right.
stuff and everything else. And it seemed a completely different galaxy to me, not even the same
Yeah.
planet.
That's,
So, no, I agree with you. And I think, it's just, things are changing, which is great. And one thing I'll say, and you don't need to respond to this at all, Chirag, but I would love to see Mr. Justice Karia before too long. Just going back to that very sweet comment when you were in your patent shoes and your buckles
yes,
and your long wig
that's right.
after taking silk. But I would love to see that. But what I always do, Chirag, when I finish these podcasts is end on a sort of light-hearted note about sort of non-law and sort of some more fun things.
Sure.
So, when you're not doing the fabulous work you do, what sort of music do you enjoy? Any groups or singers or bands, any sort of type of music you particularly like?
Well, I'm an 80s child, so I go back to bands like Tears for Fears. ELO, I was a big ELO fan, but and in the heyday of the New Romantics, I'm going to sound so corny now, but Duran Duran, ABC,
Very
all of
good.
those, Human League, all of that.
Yeah,
I
absolutely.
did all of that, and then very slowly I got into classical music, which I listened to as well. But I'm still an 80s child. But for sort of classical, I listen to some Beethoven and things like that. I haven't quite got into opera. I'm not that sophisticated. And actually, recently, I've been listening to a lot of Hindi music, so Bollywood music.
Yeah.
And
Yeah.
it's from someone growing up in England, as a sort of as an immigrant, and trying to balance two different identities, who in my teenage years would sort of actively reject Bollywood music. I can see myself going back and listening to things and absolutely loving it. So so I've eclectic taste, but certainly in pop terms, things like the Stranglers, for example.
Mm. Oh, yeah.
Yeah.
Golden Brown and all
Oh
that
God.
stuff.
Yeah, yeah,
I
yeah,
mean, no, that, I still remember the first time I heard Golden Brown and
yeah.
you hear those keyboards at the beginning
Harpsichord.
and it
Yeah,
sounds like it sounds really weird. And then you realize that's actually a really, really, really seminal piece of music.
yeah,
So listen, I mean, all the stuff you've been talking about, I can remember distinctly all of these groups. And in fact, I still think one of the best albums from that whole era was Human League's Dare album. I
yes,
think
yes,
that is definitely one of the best albums. It still sounds great now.
yeah,
And I think that was partly the Giorgio Moroder effect and everything else. But anyway, we can talk about music for hours and I can't take too
yeah.
much of your time. One thing I want to ask you just as we finish is now, fingers crossed, we're over the worst of the pandemic. And fingers crossed, more travel is going to be possible and holidays can be taken again. Is there a place, any particular place or places that you and your family particularly have enjoyed traveling to over the years and you'd love to go back to sometime soon?
Yes. I mean, the one place I would love to go back is Bali. That my wife and I went there for our honeymoon. We promised to keep going back, and something just crops up. But that is a truly magical place. It's like a sort of emerald teardrop in the ocean, and and the people are the most gentle, and there's so many wonderful temples, and the scenery is superb, and the art and the music and the kechak music and all of that. It really is somewhere completely different, a gentler pace of life, but with extremely deep cultural and religious depth to it. So that's probably one place. One place I've not been
Wow.
to, which I'd like to go to, is Brazil. And I'd also actually very much like to go to Australia, but then that's going to be a sort of 24-hour trip. And it's always difficult when you've got young children. So, mine aren't that young anymore. So we'll have to see. But then when they get older, as you probably know, they have their own itineraries and plans. And
absolutely.
So that becomes much more difficult.
I know exactly what you mean, Chirag. And, I'm sort of my wife and I are on the verge of sort of becoming partial empty nesters.
Yes.
So I know exactly what you mean. The same logistics that used to affect us years ago don't really affect us that much anymore. But still, I do hope you can get to Brazil, Bali, and of course, Australia. But look, Chirag, thank you so much. It's been an absolute privilege and pleasure to speak to you. Thank you for being such an incredibly inspirational person, a role model for so many. It really has been really, really fun to speak to you. So thank you very, very much.
Thank you, Gautam. It's been an absolute honor. And again, as I say, that all of this applies to you equally. So I really don't deserve this much praise all on my own.
You're far too kind. But no, thank you very much.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email arbitralinsights@reedsmith.com. To learn about the Reed Smith Arbitration Pricing Calculator, a first-of-its-kind mobile app that forecasts the cost of arbitration around the world, search Arbitration Pricing Calculator on reedsmith.com or download for free through the Apple and Google Play app stores. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.